Mr. President, members of the Court, good morning. And so we begin the last day of the Gambia's presentation of its case. I will address you this morning on Myanmar's commission of the actus reus of genocide. There is, in fact, no serious issue in this case about whether the actus reus of genocide has been committed. You have heard yourselves the witnesses' evidence on what happened during the clearance operations, evidence which Myanmar has not countered. In the villages where our three witnesses lived, Minji, Chutpien, Maung Nu, and in many other villages across northern Rakhine State, the Myanmar military indisputably committed atrocities. Whether those atrocities were genocide, because of the inferences to be drawn from the evidence, because they targeted a substantial part of the Rohingya group, those are questions of mens rea, not actus reus, and they will be addressed by Professor Sands and Mr. Reichler in the speeches which follow this morning. For actus reus, the focus is on what was done, not why it was done. Proving actus reus requires simply proving that any of the acts described in Article 2 of the Convention were committed against members of the Rohingya group. So we ask of the evidence, was anyone killed? Was anyone caused serious bodily or mental harm? Were conditions of life deliberately inflicted on the group which were calculated to cause their destruction? Were measures imposed which were intended to restrict births within the group? In respect of all of these, the answer is yes. Mr. President, members of the Court, in 2 painful but powerful days last week, you heard from the Gambia's witnesses of how their lives, their families, were decimated by Myanmar's genocidal campaign. Their experiences are repeated in over 40 signed witness statements and in hundreds of further accounts obtained by the FFM and the IIMM. There is no doubt that there were killings within the terms of Article 2A. Mr. Blom-Cooper suggested last week that the Gambia has failed to distinguish between killings which fall within the terms of Article 2, as opposed to the killings of those actively involved in the violence, or unintentional collateral casualties, which do not. The reality, however, is that trying to focus on this distinction, a distinction that the Gambia accepts exists in the law, does not assist Myanmar. The evidence is clear and unwavering. Innocent civilians were intentionally killed. Witness MS's daughter was intentionally shot as she tried to flee. His wife and 4 other children were intentionally forced into a burning building to die. Witness NJ's infant son was stabbed and thrown on a fire. There is no possible argument that these children were people actively involved in violence. There is no evidence, nor any assertion that they were, nor indeed that they were collateral casualties. The circumstances of their deaths speak for themselves. Even Myanmar's own evidence, which Mr. Suleiman took you to yesterday, is that 376 ARSA terrorists were killed in the second wave of the clearance operations. What then of the 9,600 other people who were killed at minimum? Myanmar provides no case that they were combatants nor collateral casualties. The perpetration of killings within the terms of Article 2A is convincingly established. Mr. President, as a final point on the actus reus of paragraph A, I underscore that it does not matter for this stage of the court's analysis how many Rohingya were killed. Mr. Blom-Cooper suggested last week that 10,000 deaths were not enough to establish the actus reus of killing because it is not enough people to contribute to the physical destruction of the group as a whole. Even putting to one side the fact that the figure of 10,000 is noted by the FFM to be a likely underestimate, limited in particular by Myanmar's destruction of evidence and its refusal to cooperate with international organisations to conduct investigations, and that there are some estimates that the death toll was more than twice as high. The Gambia does not accept that there is a numeric threshold which must be reached for the actus reus of genocidal killing to have occurred. Any act of killing is inherently capable of contributing to the destruction of the group. While the number of group members targeted and affected may be relevant to whether genocidal intent is established, an issue which was raised by Judge Orescu in his questions to the parties, and which will be answered more fully by Professor Sands in his speech which follows. There is no quantitative requirement imposed on the actus reus. The 10,000 deaths, at least, which were caused by the Tatmadaw during the clearance operations, were each a human tragedy, and they were each a genocidal act within the meaning of Article 2A. Alongside those acts, Myanmar caused serious bodily or mental harm to members of the Rohingya group within the terms of Article 2B of the Convention. In the Christich judgment, the ICTY held that inhuman treatment, torture, rape, sexual abuse are among the acts which may cause serious bodily or mental injury. Each of these modalities of Article 2B was committed by Myanmar. By way of example from the evidence, the targeting of children, including by throwing them into rivers to drown, is plainly inhuman treatment. The barricading of people in burning buildings and gratuitous sexual mutilation, torture. Rape and sexual abuse were widespread, and Mr. Lowenstein yesterday reminded you of some of the harrowing evidence in that regard. The physical and mental harm caused by these acts is of the most serious nature. Similarly serious harm was caused by those who witnessed such acts perpetrated on their loved ones. As the ICTY has acknowledged, being forced to watch sexual attacks on a woman, in particular, a woman whom the witness knew as a friend, caused severe mental suffering. The evidence here is of precisely this happening over and over again. Husbands witnessing their wives raped, mothers their daughters, sisters, friends and neighbours. And, as in the cases of MS and NJ, parents seeing their children brutally murdered in front of them. The seriousness of the harm caused not just to those who suffered these acts, but also to those who witnessed them, was evident in their testimony to the court. The extent of their suffering more than 8 years after these events continues to be extreme. It is not, of course, necessary for the harm that is caused to result in permanent or irremediable damage, though one may expect that the acts described by the witnesses and in the UN evidence are such that serious permanent harm has been caused. Nevertheless, what is necessary is that the harmful conduct causes grave and long-term disadvantage to the ability of members of the protected group to lead a normal and constructive life, so as to threaten the physical destruction of the group. This point was made in your Croatia judgment, and the serious harm caused to the Rohingya amply fulfills this requirement. Thus, for example, the serious physical and mental harm caused by the widespread sexual violence, including gang rape, contributes to the destruction of the group because it affects and impedes normal marital relations for survivors afterwards. And it affects their ability and their willingness to bear children on whom the survival of the group depends. The specific targeting of children, about which there is so much evidence in this case, and who represent the future of the group itself, also causes serious harm in itself capable of leading to the destruction of the group. Mr. President, members of the court, one of the striking features of this case is the number of Rohingya, 700,000 of them, almost the entire Rohingya population of northern Rakhine State, around 2/3 of the Rohingya population of Myanmar overall, who had to flee to Bangladesh to escape the genocidal violence of the Tatmadaw. The circumstances of their desperate flight fall within the terms of Article 2B because of the serious physical and mental harm the refugees were caused. There was a baseline profound harm caused by being forced to flee with the stark choice of that or be killed. And it was compounded by the attending circumstances. The fear and uncertainty as to their fate, and the fate of family members from whom they were separated, sometimes never to see again. The appalling conditions of their journey to Bangladesh, described by Mr. Lowenstein yesterday, including the lack of food and the ongoing threat of genocidal violence, and the unsafe and unsanitary conditions of the camps in which they sought refuge, where they are unable to live normal lives, and which, accordingly, contribute to the destruction of the group. The witness's evidence was clear about the serious harm this has caused. Recall witness MN, for example, who escaped the Tatmadaw's genocidal violence in Maung Nu, but who had to flee from his village to survive. He told you straightforwardly, in response to a question from Judge Nolte, that he was, and I quote, afraid of being killed if I didn't flee. The consequence is that he has never been able to bury and properly mourn his murdered father. You saw for yourselves the continuing mental harm that has caused him. Or witness NJ, who, leaving behind the burned body of her infant son, not knowing the fate of her husband, fled from her own village to a relative's village nearby, but found herself having to flee again when 3 days later the Tatmadaw attacked that village too. And so she commenced her arduous journey to the relative safety of Bangladesh. Members of the group were undoubtedly caused serious harm by the extensive physical and sexual violence to which they were subjected and which they witnessed. And they were also caused serious mental harm, equally genocidal in its perpetration and effect, by the circumstances of their flight to Bangladesh. In respect of the actus reus of genocide enshrined in Article 2B, the evidence could scarcely be more compelling. On a widespread scale, the Tatmadaw, acting as an organ of the Myanmar state, caused serious bodily or mental harm to the Rohingya. Mr. President, because this is the second round of presentations and because you underscored on Friday the need for the parties to be succinct in our submissions, I am not going to address the court today on the aspects of actus reus enshrined in Article 2C and D, intentionally inflicting conditions of life calculated to bring about the physical destruction of the group, and imposing measures intended to prevent births within the group. They are important features of Myanmar's conduct towards the Rohingya in this case, and they form a full part of the Gambia's case. The evidence shows that Myanmar perpetrated them. But you have our case on them. It was fully set out in Mr. Lowenstein's speech in the first round. I do not need to repeat it. And of course, it is sufficient for the purposes of your determination if any manifestation of the actus reus was committed, a feature which, on the body of evidence that exists, is conclusively established in this case. Indeed, Mr. President, members of the Court, when you consider all of the evidence in this case together, the signed witness statements before you of survivors and eyewitness, the hundreds of statements taken and relied on by the UNFFM and IIMM, the satellite imagery, the NGO reports, when you consider what all of that evidence shows, evidence on which, as Mr. Reichler explained yesterday, you can place substantial weight, there can be no doubt about the existence of the actus reus of genocide. Sadly, the evidence easily reaches the threshold of fully convincing. The first of the legal constituents of genocide is established. The second legal constituent, the mens rea, is what Professor Sands and Mr. Reichler will address you on next. Members of the Court, I thank you for your attention this morning and over the previous 2 weeks of this hearing.